Okay, so they on break right now. Good morning. So why they do that? Oh goodness. So from what it looked like today, they trying to get some more things situated about with the witness situation. Seemed like the judge is on the prosecution ass because they're unorganized. So yeah, seems like this gonna be a long one. I mean, but we could come back to that since they're on the recess. I don't know for how long. Let me see if I can see how long she said they're gonna be in recess for. Okay. Well, okay. Somebody in the comments that said the judge still gonna push through with the pre-trial. I mean, with the push forwards with this trial, no mistrial will be seen here. We don't know that. We don't know that because we ain't even. Right now, I think she's trying to get on these lawyers, man. Prosecutor and defense because, but more the prosecution because they really unprepared. Y'all haven't been given information to the other side that y'all had. Y'all haven't imparted, and it's crazy. Having meetings y'all ain't supposed to be having. So like I said, see, they didn't even say how long they was gonna be on break for, but it might not be long. So what I'm gonna do is go here, and we gonna open a new tab. So till they come back from break, I guess we can holler at Cuff Boys and see what's going on.
Save big now at Joe Cicconi's Chrysler Complex. You can lease this 2025 Ram 1500 Tradesman Crew Cab for $499 a month. Make this the summer event going on now at Joe Cicconi's Chrysler Complex. JoeC's.com.
And was the ex-parte transcript that you read a complete recording of absolutely everything that took place in chambers that morning?
No. What I'm saying is,
ma'am, answer the question I am asking you.
I didn't realize it was a meeting.
Did Kenneth Copeland ever say to Simone Hilton, I killed Nutt?
No.
Did Kenneth Copeland ever say to Simone Hilton, I killed Donovan Thomas?
No.
See, that's not a good look. Day 105 of the Young Thug YSL RICO trial was a disaster. Woody's attorney Kayla Bumpus and investigator Long both take the stand and give contradicting statements on what happened in the ex parte meeting. I know this is becoming a catchphrase of mine, but today was truly a complete shit show. Defense lawyers try to prove that Miss Love is a liar. Then later on, Miss Love tries to prove that Mr. Melnick is a liar. And at the same time, you can tell the judge doesn't care about any of this and just wants to continue with the trial. So yeah, join the channel membership. It's only 10 cents per day. Bonus video per week too on there. Hit subscribe. Here we go.
I know we have Mr. Melnick outside.
So Woody's lawyer, Mr. Melnick, is here to basically try to expose Miss Love for lying and Miss Hilton.
Put some things on the record.
First look at Thug on day 105 right here. That's a clean sweater.
Representation made by Mr. Steele at the end of the day, Friday, that he has good faith basis to believe that there may have been an unrecorded conversation at some point that included Miss Hilton, Miss Bumpus, and Mr. Copeland that may have resulted in some Brady material. You know, I think it goes without saying that people can perceive the same thing in different ways depending upon the perspective they're standing at the time. And I'm going to permit you to make a brief proffer of what you believe happened. I do not think that you were laboring under any conflict of interest. I don't even know that at this point in time any of that is particularly relevant, but I can understand you wanting to put something on the record. I would like for you to stick to the facts to the extent you can. Keep emotion out of it. Go ahead.
So, Judge, basically what it comes down to is after receiving the transcripts from the two ex parte hearings that took place, or ex parte meetings that took place between Judge Glanville and the District Attorney's Office, and then with Miss Bumpus and Mr. Copeland in tow, the allegation has been made that I was somehow acting in conjunction with Mr. Steele and Mr. Shart and other members of the defense team in this case, which is categorically untrue. I am unfortunately in a difficult position as it relates to this issue because what I would need to produce from a document.
So my thing is this too. The prosecution been doing a lot of bashing the lawyers, and I don't know. I just feel like it's games. It's too many games being played as far as the state go. It's a lot of things going on with the justice system right now. It's crazy. So you know, can't trust the justice anyway. And now it's showing and proving. Like a lot of these people lazy, don't want to do their job. I don't understand how this case is going on, and you don't have all the information that you're supposed to have. It's constant nonsense going on. So I don't know. But I'm just like anybody else who's watching this. This is just something I've been interested in because, you know, it's rappers or whatever like that. But yeah, it's real interesting to see. Once again, I say it again, I think it's a money grab. So whatever. But let me light this press up, get this joint, and get back to it.
Documentary standpoint, rebut these allegations are privileged communications between myself and Mr. Copeland. Starting with June the 6th, I sent an email to Miss Hilton, Miss Love, Mr. Steele, and Mr. Shart stating that Mr. Copeland wanted to take the fifth, did not wish to testify. On the 7th, I was shown an order that was signed on June the 7th stating that Mr. Copeland was being given transactional immunity.
Isn't that something? As soon as they're getting word that he might plead the fifth, they're like, oh, we got to give him forced immunity so we can lock him up and force him to testify. That's pretty much what that meant.
At no point did anybody from the DA's office within any relevant time frame reach out to me. Just ask me if I was representing Kenneth Copeland for purposes of his testifying in this trial. Everybody in this room that has been involved in this case from the beginning has known that I was representing Kenneth Copeland.
All right, and I know because you had a case before me
With Mr. Copeland.
with Mr. Copeland that resolved in June of 2023. So
correct.
I know that as of that point, you were representing him.
But I do know that on June the 6th, he and I spoke, and he told me that he wished to assert his Fifth Amendment privilege. And so I sent that email. The transactional immunity order was granted on June the 7th, which I find the timing there to be, let's just say, ironic, in that apparently they were going to have Mr. Copeland testify without any grant of immunity because it was the state's intended purpose to call him as a witness on June the 7th. Nothing that I said or did on Mr. Copeland's behalf was done in any conjunction or with any consultation, in cahoots, or anything along those lines with Mr. Steele or Mr. Shart or anybody else doing what my client had expressed to me.
So now I know I'm not the only one that was thinking that Miss Love and Miss Fannie Willis is I think they in cahoots, man. As well as Glanville. And what I don't understand is the Supreme Court should be able to like see this, and you gotta give some of these people something. They've been sitting in jail while y'all playing like this their livelihood, bro. They got families, got things going on. And ultimately, it's a lot of cases where people are innocent. So if you're trying to prove somebody guilty, prosecution, I mean, it shouldn't be that difficult. You having all these witnesses and all of these things. So, and yes, I do give it to Ryan Steele. He's a great lawyer. All the other lawyers on the case are great lawyers. But what I'm saying is, me personally, I've never seen prosecutors this sloppy ever. So what I'm saying is, I think it's a purposely. It's doing sloppy work purposely to try to put the jury in a frenzy. So that's what I'm thinking about it, man. Because why is all these lawyers? It's like every lawyer them been bashed or said they or accused of doing something out of it. But it's mainly the prosecution who keep messing up.
What he wanted to do. And as I said, if it becomes a major issue, I have more than enough documentation to prove that.
Okay, I appreciate that. It's not an issue at all to this court.
That's it, really? Is Doug asleep? He's looking real tired.
Otherwise, we might just move on.
So Steele wants to ask Melnick questions.
About an email with a BCC, and it was sent inadvertently. I believe that he'll say that's not accurate. And then we sent your Honorable Court on Friday all of the emails. If you put them in order.
Yeah. Okay. I mean, I've seen it. I think that's fine if you want to ask him that and clarify it. I don't think that Ms. Love made a representation that is in fact what happened. That was her theory because she couldn't figure out why Mr. Melnick was referring to her in the third person. But sure, you can ask him that.
Did you make it clear from your viewpoint that you were representing Mr. Copeland in this case, meaning the case that's on trial before Judge Whitaker?
Yes.
As a witness or as a potential co-defendant?
Yes.
At any time did you or any member of this Attorney's office in your presence ever say that you were not representing Mr. Copeland pursuant to a potential witness in this trial?
No.
Ms. Love was seated to your left?
Yes.
About representing Mr. Copeland as a witness in this trial?
Yes.
And when were those conversations?
March of 2023.
So this is where the state could be lying. They say, or at least Miss Love says, and Miss Hilton, I think, that Woody told them Melnick wasn't his lawyer anymore.
My client will assert his privilege under the Fifth Amendment tomorrow and will not testify. Thank you, John Melnick.
On the 6th, and you made it clear, to your knowledge, was there any type of immunity agreement whatsoever in place? Use of immunity, transactional immunity, any type of agreement?
There was no response from the District Attorney's Office to this email to me, so I was not aware of any immunity, any offer of immunity to Mr. Copeland at that time.
That he could be making statements that would incriminate himself?
Yes.
No statute of limitations ran? He could be charged?
So I can't say that with absolute.
Okay, well, we're dealing with a bunch of lawyers, so I think Mr. Melnick can handle it. I'm not overruled it.
She objected to a compound question.
In our conversations with Mr. Copeland, he advised that you were not his attorney.
Somebody in the
and
chat
not
just
spoken with
said-
you. However, if you are asserting that you are his attorney, we will cease communication, but your client is under subpoena and is expected to be.
Somebody in the chat just said the judge should have Miss Love arrested in court on national TV. So I know I'm not tripping. Like everybody else is seeing this clown show going on. This is such a bad look for Miss Love. Didn't think it could get any worse. If she says no, why did it take her 30 minutes? If she says yes, we had all this evidence, then why didn't you turn it over? Biggest L ever. I agree.
Be here at 8:30 a.m. It is our understanding that your client does not have transportation, so we're planning to pick him up. So please make sure that he is present, so we do not have to take any further action if he fails to appear for his subpoena. Thank you and have a great evening. And that's from Ms. Hilton.
Did you respond to that email? And if yes, is it on Mr. Williams number 2? And what does it say in time and date?
It is. I did respond. It's dated June 6th at 5:47 p.m. Again with CCs to everybody in the case.
So did Woody actually say that? But either way, I feel like the state should have been in communication with him to confirm that he's not his lawyer.
I have been Mr. Copeland's attorney. He tells me that he repeatedly told you that when you were questioning him. I spoke with Ms. Love early in the process, around the time jury selection was beginning.
Is everything that you responded about being Mr. Copeland's lawyer for purposes of this case true?
Yes.
So Woody told him it's the exact opposite. He said he was his lawyer.
That is an email dated Thursday, March 2nd, 2023 at 4:42 p.m.
And you're forwarding that in June of 2024 to say, see, you knew at some point I was representing him. Okay.
That's correct, Jen.
So contradicting evidence, the state clearly knew Melnick was representing Woody.
What Mr. Copeland did on June 7th of 2024, where he asserted his Fifth Amendment privilege, was entirely his decision. I was there just as his mouthpiece, as a lawyer, as his advocate for purposes of him asserting his Fifth Amendment privilege. Other than that, I have absolutely no agenda in this case whatsoever.
Email from you asking who Mr. Melnick is most concerned about or something like that. And then Mr. Melnick's rather peppery response back. Okay, so it's just...
Melnick said, go f yourself. Look at him smiling right here. Look at that smile. Like a Disney villain character or some shit.
Yes, I did not blind copy anybody on that last email. I just sent it to Ms. Love and Ms. Love.
So apparently the BCC that Miss Love talked about is not true, because he just said he didn't.
Have myself or Mr. Steele ever gone behind your representation to your knowledge and attempted to speak to Mr. Copeland without your knowledge and understanding?
I have no knowledge of that. I'm not aware of any time that would happen.
Have you become aware that Mr. Copeland was in the actual courthouse speaking to the state on that week?
I became aware of that on either June 6th or June 7th.
Did you know anything about that as it was happening?
I did not.
In that conversation, did I ever ask you to do anything on behalf of myself or Mr. Steele or our clients?
Absolutely not.
Did I ever ask you to stop Mr. Copeland from testifying?
Absolutely not.
As a lawyer, is it appropriate to contact another lawyer about their client?
Objection, Your Honor, as to this witness being qualified to speak about what are in the ethics.
I would hope that every lawyer in the state of Georgia is qualified to speak on what we're expected to do under our code of ethics.
Wait, what was that objection? That was the worst objection I think I've ever heard. How is either one of these lawyers not qualified to speak about the code of ethics?
Looking at Defendant Williams Exhibit number 1,
So many of our biggest problems have already been solved. Housing, healthcare, energy are not intractable. In fact, the technology exists to solve these problems, but those technologies have to get over regulatory.
is that an extraction? In other words, is that a portion of an email cut out and isolated from a larger email?
I don't believe so.
I can't believe we're wasting this much time on this.
Could you tell me whether these two documents contain the content from the same email?
So the content appears to be the same, other than the fact that on the one that you just marked, there what appears to be the seal from the Fulton County the Atlanta Judicial Circuit.
Are you able now to say with any more clarity, Defendant Williams Exhibit 1 is a document, a piece of paper where a portion of the email chain that is contained within Defendant Williams 2 and State's Exhibit 1 has been extracted and pasted onto a piece of paper?
So I can't speak for how Mr. Steele printed this up.
Is she pointing out that it's a screenshot right now? Court today is going to make me have to go sign up for BetterHelp. That's right, boys. This video is sponsored by BetterHelp. Therapy can help you have better relationships, stronger coping skills, and a better sense of who you are as a person. And I know a lot of you watching this video have gone through something traumatic, and it's always good to talk to someone and get it out and not harbor it inside. And this is why BetterHelp is amazing, because it's all online and you can fit it in your busy schedule with their scheduling system. It's extremely convenient and flexible, and you can pick whatever day or time you want to do. We all know life is about having fun and having a clear mindset and making sure mental health is a priority, and BetterHelp can be something that impacts your life in a positive way in your work life and your personal life. I've personally witnessed family members and friends go to therapy and then months for a lot of questions
Of chain of communications between myself, yourself, Ms. Hilton, Mr. Steele, and Mr. Short. So this is just part of the same line of communications that we were having, where I said, Mr. Copeland didn't want to plead, didn't want to testify, wants to take the fifth. Ms. Hilton responds, and then I respond to her response. And in her response is where you get your insignia for the Atlanta Judicial Circuit.
Okay, so let me be clearer. The exhibit that is labeled Defendant Williams
I don't understand her point right now.
Exhibit 1. Did you ever forward that separately to Mr. Steele or Mr. Sharp?
I think I just forwarded. I mean, I wouldn't have had to because they got the emails.
Given that State's Exhibit 1 looks as it does, are you saying that the email that is Defendant Williams 1 is the entirety and not a part of any other email chain.
This email.
Not a part of it. It's clear. It's the first email of an email chain. What's her point here?
Was the first email sent. Okay, so when I say this email, I'm referring to Mr. Williams'
All right,
exhibit number
back.
1. Was the first email sent on June the 6th of 2024.
I don't know why
That
I
is the
like
first
this
email.
judge, man. She
Mr. Williams'
might be
exhibit
my
number
math
2
teacher,
is
dude.
the continuation of that chain of emails.
He did 2
fucking made
exhibits.
that
One's
lady
working out the
cry,
other
bro.
2.
And it pissed me so bad. I forgot her name. She was pregnant though, and I love that match. She was so nice. But she reminded me of her. But she is not bullshitting. So, Cuff Boys, we'll be back. We'll get back with you in a minute.
I mean, if I said that, I'm repeating these states. In the meantime.
Yes, Your Honor.
All right, thank you. Something else. Something else in the meantime.
Yes, Your Honor.
All right, thank you.
Your Honor,
Yes, sir.
can I just add one thing to the previous discussion?
Sure.
A lot of the state's theory is that Mr. Williams is in charge of a gang and the gang does crime on his behalf. He asks for it and they do it. We deny that. I heard the court say and I heard the prosecutor say that this is inculpatory, no exculpatory. Everything could be inculpatory or exculpatory.
Okay. Can I just...
Of course.
I didn't say it's inculpatory. I don't know. Okay. I said the state, I mean, if I said that, I'm repeating the state's maintaining that it's only inculpatory.
I understand.
But, okay,
and I appreciate it. And all I want to make the court aware as you go through decisions is if we knew about Mr. Boyer, then what I would have done is found out if he has a lawyer, because he's in custody, it sounds like, contact his lawyer, ask if I could go with the lawyer and Miss Adams, when I say me, and Miss Adams, and an investigator, and interview him. And he may give information that's very hurtful to me. He may give information that is very beneficial to Mr. Williams. I don't know. My point is, though, that the state has no ability to know what's helpful or hurtful to Mr. Williams, and we have a right to investigate. So I just wanted that on the record as well, in case this goes up. Thank you.
I don't disagree. Thank you. I don't disagree. All right, Ms. Lev, if you're at a stage where you can shed any further light on anything, great. If not, we'll take it up after lunch.
I'd like to take it up after lunch if the court will allow me. And I wanted to make clear I'm not refuting anything regarding the need to provide it to the defense and whether it's inculpatory or exculpatory. I just wanted to make clear and make sure that I told the court and the defense that we're not asking to use it. We just wanted to, out of an abundance of caution, in the event that it is in some way, in any way exculpatory, give it to the defense. We're not trying to use it.
Okay. All right. Thank you. All right, let's turn back to Mr. Zachary's statement that we were going through yesterday. And Ms. Love, you are going to take the overnight recess to try to determine if there are parts of the proposed redactions that you agree to. And Mr. Shard, I know that, I don't know if it was you or Mr. Atkins that shared the the 3 pages of the proposed redactions with regard to this interview that we're going through right now. And honestly, there's not a date on the binder that y'all gave me, so I don't know what date to reference. But you have proposed redactions for the other interview. Can you share those as well so I have something to go by?
I will. I'll send them over right now.
All right, thank you.
And Your Honor, just for the record, number 38, which is the next one, according to my records, I'm withdrawing my request on that one.
Okay.
We don't need to.
Thank you. And what is the date of this interview?
This one is April 27, 2017.
April 27th, 2017. All right.
No,
thank
April 13, 2017.
13, 2017. All right. Thank you. Okay. So, Ms. Love, I know you're looking for them, but did you get an opportunity, and are there redactions you agreed to?
There were not a lot. There was
Okay.
only one.
But you're going to find whatever that was and let us know.
Right.
Okay.
And I marked them in the transcript.
All right.
That's why.
This is bad. Only thing I can think is these people getting paid very good. See, I wouldn't be part of this at all if I worked like as a lawyer, as a judge. I wouldn't want nothing to do with this case. It's terrible. Clown show.
Actually, the one that I thought that I did agree to, okay, here it is. So number 76, again, the discussion about the injuries
All right.
of certain part of the body, and that would be page 259, line 20.
Yeah. So you agree that that should be redacted?
Yes.
And that's the only one between 39 and 75 that you agree to?
Yes, and the reason that that is the case, I'll just say that I went back and was listening to the context. So
yes.
I did read Mr. Sharp's reasons for wanting to exclude it, but I wanted to just make sure that it wasn't necessary for a larger reason, and I'm prepared to express and explain why those are.
All right, well then let's just get back to it. We're on number 39.
So, Your Honor, number 39, I was shorthanding this. When I wrote yak,
Sure.
when I wrote yak, that's Mr. Kendricks.
Okay.
So, my understanding from my recollection, is that Investigator Dennis has never spoken to Mr. Kendricks about the murder of Donovan Thomas. Okay, that's my understanding. But either way, whether he's spoken to him or not, I believe he's just using a technique to try to suggest that Mr. Kendricks has said things.
Right. Excuse me.
But to the extent, either way, he's putting words in Mr. Kendrick's mouth. Mr. Kendrick may not take the stand. That's up to him. But I don't think it's appropriate for Investigator Dennis to state on a out-of-court statement for the jury to hear what Mr. Kendrick supposedly told him about the events of January 10, 2000.
And Your Honor, that's at the bottom of.
Yeah.
And I can also provide the court the timestamp for it on the video that we've just given, but it's at 16:32 in the video of this portion of the interview. And when the court is prepared for me to, I can respond.
I'm prepared for you.
Okay.
Too.
So, I hear and understand what Mr. Shard is saying. I disagree with it. When Investigator Dennis says that Yak said something different, and nowhere does he assert, hey, I did this. Everyone knows there's not a dispute, I think, that Mr. Kendrick made a statement and says something different. And when Investigator Dennis says that Yak says something different, just to give the court some context, the 2015 interview that this witness gave contained inculpatory information concerning Mr. Kendrick, Mr. Stillwell, and others.
Okay.
By the time we reached 2017, it has been circulated that interviews have been conducted. Jail calls reveal that co-conspirators, at least alleged co-conspirators, people that we allege are co-conspirators, are aware of the content of some of these interviews. And at this point, Mr. Zachary is now saying he's backing away from it. He doesn't deny, he never denies that Defendant Kendrick and Defendant Stillwell said to him the things he said in the 2015 interview.
Right.
But now he's proffering theories about their actual involvement. He's saying, yes, they said that. They did say it. And when Detective Dennis says, after Mr. Zachary gives him a rendition of events, and Detective Dennis says Yak says something different, there's nothing about him meeting, and the argument could be made by the defense. You heard Mr. Kendrick or whomever wants to make the argument, but that is a piece of evidence that will be put in at trial at the appropriate time. So
that piece of evidence being
Mr. Kendrick's
statement where he does in fact say something different.
Yes.
Is that what you're
about
saying?
himself, yes.
Okay. So, and he's already made whatever that statement is by the time of this 2017 interview with Mr. Zachary.
He has.
Okay, and so whether Investigator Dennis talked to Mr. Kendrick himself or not, Mr. Dennis is aware that in fact Yak did say something different.
Right. He's saying right. He's
and
it's a broad.
Okay. Does Mr. Kendrick's interview, when we get to the top of page 116, Investigator Dennis is saying Yak said he was on his way to his girlfriend's house, I guess.
He does say that.
Okay. All right, and so.
Your Honor,
Yeah.
I don't believe that's an accurate. I know why you're asking that question, and the spirit that you're asking that question, I don't believe that's accurate. Mr. Kendrick, first of all, a couple of things. My understanding, Mr. Kendrick's statement has been suppressed.
Oh, no.
I don't think it's coming in.
She says no.
Judge,
y'all,
the portion of the statement that it contains what we're discussing was not. What was Suppressed is a portion where another detective comes in and starts talking to Mr. Kendrick.
Okay.
So there's a very long part of the
Before the part that is
Yes.
suppressed, and it's in the unsuppressed part that the representations that you
Yes.
just made are contained.
I don't. Investigator Dennis on 116 line 8 says Yak said he was on his way to Bush's house
Yeah.
and they saw Nut at the barber shop and they made the call. I don't know if Mr. Kendrick is saying that to any law enforcement.
Well, we ought to be able to check that. I mean, right? Like the statement is.
And the made the call portion, I'll agree. That part he didn't say. But the part about him being on the way to Bush's house, which is what I think is the most.
Oh boy.
He didn't say he saw her at the barber shop. My recollection of the statement, and Mr. Weinstein's most on top of what was said.
Miss Love need to come on with the nonsense. Good. She need to come on.
He
Like,
said,
please,
I did not have anything to do with this killing.
Dragging.
I went
like,
to my
this is gonna be a
girlfriend's
mistrial.
house.
Please,
That's
bro.
my
Come
alibi.
on, man.
I don't know.
Man.
So the state, yes, he said he was with Busha in a car with her going to her house. He never said seeing Nut at the barbershop and making a call. That was not stated. So that's a misrepresentation of Mr. Kendrick's statement, first of all. And secondly, I mean, it's just completely confusing to the jurors.
Okay.
So, Your Honor, the state's response to that is when I stated there's information that Mr. Zachary and Detective Dennis exchanged before we reached the point where he says that's not what Yak says.
Yeah.
And the reason that that is important is that there's a compound sort of statement at the top of 116, and Mr. Sharp is correct regarding Mr. Kendrick not saying we made the call, but the part where he says he was on his way to Bush's house.
Right, that's not the part at issue. It's
Right.
and they saw Nut at the barbershop. Does Mr. Kendrick in his statement say anything about seeing Nut at the barbershop?
My memory is that he doesn't say they saw Nut at the barbershop.
Okay.
My memory is that he doesn't say that they saw Nut at the barbershop.
Okay, and
But that he was on his way to, so I'm not disputing that part.
Okay, so then that part needs, I would think, to be redacted out because it is confusing.
I have no problem with that. I just wanted the court to be aware of why, of the argument that we were making.
Okay. So
if the statement is going to be introduced as evidence, the reason that we were not conceding that part is that Detective Dennis's
that part's fine. I understand everybody's arguments, so let's get to what we are redacting out.
Yes, Your Honor.
So, page 116, line 9, and they saw Nut at the barbershop. Frankly, why don't you just also skip line 10 and line 11?
Okay.
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 Does that satisfy your objection, Mr. Sharp? Okay. Next one is on 117. No, what I'm looking at is number 40, which is what, oh yes, on the other one, no, 9.
You said,
Going
Miss
back
Love,
to
please
number
don't transfer to
39.
Cobb County. That is hilarious.
Yak said he was on the way to Busha House is
Cobb's
fine.
terrible.
So the part that says, and they saw Nut at the barbershop, that part of 9, and then all of 10 and 11. Okay.
And just to clarify.
Shout out Lemon Street, though. For sure.
Okay. Thank you.
Somebody said the state is a RICO act. No, they don't. They don't need Fannie Willis there. Fannie can stay where she at.
Next one, Mr. Sharp, your objection is to the investigator's statement, right? Or also
They said you want to see some ass. You ain't got no cash to in the trial. Yeah.
Mm-hmm.
Yeah. Don't do the jazz like that.
Right. In time frame. Okay.
Freaky
so,
Fanny is crazy.
So, I would think maybe to avert that issue, can we
Maybe
consider
in the chat
a redaction
crazy
for 117 lines 23 through 25, and then just start with 118 line 1, beginning with everything you just said pokes holes in everybody's story, because then Zachary says, yeah, you know, it does poke some holes, because you don't seem to be objecting to the answer. Okay, that's fine. Well, oh, like 3 or 4 or 5 is the answer. Okay, I thought he was saying this is the number of holes it might poke. Okay, yeah, no, that makes more sense. Okay. So, 118, okay, so redact by agreement, then 117 line 22 through 118 line 2, the word story, and just pick back up with because of Demikian. All right. Okay.
Closer to me or further from me? Yes, ma'am.
Closer so we can hear you. All right. All right, why do you... All right, so the objection as to the 41 is that it's speculation. Is that right?
It's a hypothetical. If it did, I'm reading that as if they did it. I don't think Demikian had anything to do with it. Why? He ain't take it like you said, look at me and like little brother. I think in context, what he's articulating is people look at him as a little brother. And I mean, he wasn't there. He's not offering firsthand knowledge. He's just giving his theory that I don't think Demikian would be involved with something like that if they did it. And I just think that's
okay. Does the state want to respond?
In as much as this is something that is repeated throughout Mr. Zachary's interview, and in as much as there is information that Demikian gave to Mr. Zachary, similar to the way that he gave information to another witness in this case who's now on the stand. The reason that I believe that this should remain in, is that Mr. Zachary, at one point, Mr. Garlington was charged, but not by the state. And Mr. Zachary was in a position, he was with Mr. Garlington, Mr. Kendrick, and Mr. Stillwell after the murder, following the murder. So in as much as he makes the assertion, he later says more stuff like, Demetrion never told me that he did it. He talks about what each person said to him. But I'll defer to the court. It's just that's the reason that I wasn't asking or conceding immediately that come out.
I mean, that seems like a valid objection. So we're going to strike 118.24 through 119, line 5. I'm sorry, line 4. All right, and this is the witness, Zachary, relating what Demetrion has told him, and the objection is hearsay. What's the state's response?
Demetrion's statements to Mr. Garlington, I'm sorry, to Mr. Zachary. Much like the statements that Mr. Garlington made to Mr. Copeland are statements of a co-conspirator. Later in the interview, Mr. Zachary expressly said, essentially, it was a matter of keeping us all in the stuff, the information that was exchanged. At one point,
Other evidence have shown any piece of evidence, Andy. I mean, what are we doing here? We're coming here and then we're going here. I don't know what we're doing here, but basically, what are we doing here? You know, Trevor, I was watching Trevor 8 your ass. Dude, funny.
Okay, so that would certainly make sense with regard to anything that got told to other alleged of the gang right afterwards at the condo. As to this particular statement, Zachary actually gets asked, when did he tell you about that while y'all been locked down? And Zachary says, yeah, well, I've been locked up. So when was that? When did they get locked up?
So, in the latter part of 2015.
Okay, and so if that is when this story gets shared.
So during that time, other evidence will show that as a result of the murder of Donovan Thomas, there were conflicts that existed both in to answer the court's, what I think the question is how do you keep it safe? So there, the conspiracy that exists.
Get her the fuck out of here. Over here making love, over here making things up. Now that there's a judge that isn't black, corrupt, taking up his love is looking like an amateur. They got the buying license from the crackhead. Yeah. Facts. Oh my goodness, dude. Waste of time.
So the fact that Mr. Garlington is sharing with Mr. Zachary that happened, I would argue
What?
Co-conspirator exception, or it still makes it admissible as a co-conspirator statement, but
It's happy going
it's not
crazy.
something I'll hang a hat on and the court sees it differently than this one did.
In fact. Raise Love looked like a freaky principal. I know her husband get roasted by his boys. Oh, Jingle Bell Blazing the Summer Lover. Oh, boy. Oh.
It is a co-conspirator statement. These statements within the rest of the interview that are very similar to this are all co-conspiracy. And for that,
That's a fact. Got their CV with Chat GPT.
I just leave that fact. Of course, it's not one that I want to. I refer to the court's decision, whatever it is. But I'd argue that it is a co-conspirator statement, but there are more statements similar to this made by Mr. Rollins to Mr. Zachary that he alludes to. So I'm going to make similar argument about other statements like this, but that means I'm not going to object strenuously to this particular one. Object.
All right, so late 2018, are there?
Can I give Your Honor a little context?
Yeah.
So, Mr. Garlington and three other individuals, I believe it was three other individuals, including my client, Mr. Stillwell, warrants were taken out for them in around October.
Jago said 1-2 is a lie.
Based on the testimony or the word of a gentleman named Nicholas Robinson, or depending on when you ask, but he gave the statements to police.
They is frying Miss Love right now. I'm sorry.
Warrants for these gentlemen.
Love equals a partridge and a pear tree.
From the scene, Nicholas Robinson was not present where he claimed to be on the scene. So at the time of giving these statements, Mr. Garlington, and there's jail calls that I believe reflect this, Mr. Garlington is in extreme prove my innocence, shift blame mode. He's not in any sort of co-conspirator or in this together mode. And he is asserting to anyone and everyone that will listen is, I didn't have anything to do with this. I'm wrongfully arrested. He's asking people to get video from the McDonald's on Cleveland Avenue, video that we still don't have, that will show he's innocent. And so these conversations that Quindarius Zachary is saying Mr. Garlington had with him are, from my perspective, for the purpose of asserting his innocence and shifting blame to others. So that would not fall under 801 D2E.
All right, and that's sort of what I'm trying to sort out is this a time that is, when this is shared in furtherance of the conspiracy, or is it not? And if there are, in fact, still beefs going on inside the jail or outside, I mean, do they get released after late 2015?
No, it dies down a lot.
No, sorry. I just asked a compound question. So I am wondering about what is the state of the beef back and forth. And then I'm also wondering, do Zachary and Garlington get released after they're locked up in late 2015?
No. So
Okay.
they get released at some point later, much later. Zachary gets prison time, Garlington also.
Right. Okay, but not at a point in time when, like, they might be out in a week, and so they need to know what's going on the streets, so they all need to.
Well, not on the streets.
Okay, so tell me, is there in the jails beefs back and forth where they all need to be on the same page about something? Tell me, how is this in furtherance of the conspiracy?
So while they are in the jail, while they're speaking, and not to this, at this point in time, while they are in the jail, inclusive of this point in time, there are continued, there are statements made and conversations that are had about different YSL members getting beaten up by gang members. So there's evidence that we have to show of a continuing conflict within the jail and within.
Okay, how does Mr. Garlington telling Mr. Zachary I wasn't involved in furtherance of the conspiracy? Well, and the Woody picked me up after the shooting. I mean, because that's really the thing that he says. How does that further the conspiracy?
Our argument is that it fosters cohesiveness in information shared between two YSL members while they are in the same predicament of being defined among other persons who are members of an opposition.
All right, so I mean, I think the fact that on at 122 page 122 lines 1 through 3, the answer being that Garlington said, no, he does not. He says that Woody picked him up after the shooting. That's not, hey, Betty, I've got absolutely zero to do with this. It is still something that could in some way be against his penal interest. So I am going to find that to meet that co-conspirator exception. So I'm going to overrule the objection on that one. Yes. Yeah, no, I understand. I understand. But yes, that's probably a good idea to clarify that for the record. All right, so moving to number 43, which starts the beginning of page 124 and is most of that page. All right, what does the state say about this one?
The argument is that it's hearsay about what
Is that the argument, or is the argument here? I mean, at least what's on the Yeah. False hearsay, if you will.
I'm sorry, I was looking at 42. 43. 43.
Yeah. Yeah.
Was my impression and really for my notes.
Sit down,
the
boo
fact
boo
that
draws
whether it
love.
was truly what Demekian said or not truly what Demekian said, the falsity is irrelevant. I take exception to Investigator Dennis relaying in a statement that would be heard by the jury what Demekian Garlington supposedly said to him. Demekian Garlington is not going to take the stand, to my understanding, in this case.
All right. Is Demekian Garlington's statement going to come in?
No, his statement to law enforcement will not come in.
Okay.
And for that reason, I don't object to 1 through 4 on page 24, but when you get into exactly talking about what was shared to you by Mr. Garland.
Damn, what did they kick Hilton off the case or something? Miss Hilton's at the Hiltons.
Objection, the redaction requested 1 through 22. So, in as much as the argument made just now by Mr. Sharp is his objection is to Detective Dennis relaying what Garland said, there's no objection to that question.
Okay, so you're saying 5 through 22 is essentially just questioning. It's not any true or false assertion of what Garlington said. It's just him asking questions and Zachary answering them, right?
So, it is sort of, it's him, so
People in the chat is crazy. Legend has it that if Lil Jeff was to make pigeon noises, the Birdman would save him.
I apologize for doing this. It is
Where's Mr. Harvey at? Right. He getting a big back there. He back there.
Mr. Zachary acknowledges knowing that the police talked to Demekian Garlington. And in as much as that is within 1 through 3, I'd ask that the court keep that in and allow me to change that portion of my previous representation.
Okay.
The
is there
jacket ain't
gonna-
great.
Well, what are we doing about line 4?
That's the part that
McDonald. Ooh. McDowell's home of the Big Mick. Why is they doing that love
so
like
then
that?
let me go back to Mr. Shart. If 4 is redacted out, then what is your objection to the rest of it?
I do. So, to the extent
Bob
that
the Builder.
it's being brought in for Quindarius Zachary's answers,
Yeah.
and this is gonna
Sorry.
this is gonna bleed into number 44 on my list.
Okay.
It goes into my understanding is this information Quindarius Zachary is giving
Bob the Builder.
Dennis
I'm
is
trying.
based on things Demekian Garlington. It's being asserted that Demekian Garlington told Zachary in the jail when Garlington was trying to proclaim his innocence.
Okay.
So that is, I don't feel that these answers fall under the 801 D2E because, again, I don't feel that they're in furtherance of a conspiracy. The statements made in the jail. So that would be my objection to the answers.
Okay.
And those are interspersed in what I objected to in number 43 and then specifically in 44 as well.
Okay.
considering, if it comes to clarity, in considering
It's not a nice jacket, bro. Stop.
what Mr. Zachary is telling us and making a determination about what is true or not. Mr. Zachary is lying.
Oh my God. Old Black Salvation Army outfits. Yo, dude. I can't. These people in the chat. Yo.
What he is saying.
Remember, AV currently.
In line 13 through 16, he says, that's what's reflected in the transcript. That pushes back. And then Dennis is asking another set of questions, and Zachary is correcting Dennis. With information that he got from Robinson, again, still during this time, they are in confinement, and still during a time when there is still beef, if you will, between the two groups, YSL and YSL. So, to the extent that Robinson may want to get out of jail, I'm not understanding there to be any argument that Burlington is somehow aging on him, just that Burlington wants to get out of jail. And somehow that makes this not a focus.
Right, that he's no longer saying anything. He's saying about, here's what happened, Zachary. Hey, Zachary, here's what happened. Because you're my fellow gang member and you need to know this. He's saying, I am innocent of all of this, in the hope that either, I don't know whether he cares whether Zachary believes it or not, but in hopes that that gets out.
And my position is that would be an argument to make. Obviously, the jury can take what they hear and put.
Okay, but I have to make an evidentiary determination whether this is a statement made in furtherance of the conspiracy, which is what we're discussing.
And our position is that it is for the reasons that we've given to the court.
All right, I'm gonna allow it. And that would be what you cover in your item number 43. And then what I've looked at right now is the first part of your 44, which is through page 125, line 15. It looks like then there's a second set of facts. So I hadn't looked at that or made a ruling about that yet. So
I understand.
okay.
And we can get to that if Your Honor would like to, because number 45 I'm going to withdraw.
Okay.
So that puts us back at the second part of 44.
Okay. All right. So the second part of 44 is on page 126, well, all of 126, and then half of 127. So let me take a look at that real fast, and then is it the same argument as to this also?
Yes, Your Honor.
Okay, let me just take a look at it. All right, let me ask you, on page 126, lines 15 through 18, that's, I mean, seems like there might be a separate objection to that little part. Or you had withdrawn the gun part anyway?
I understand, Your Honor. He says that's
I mean, if you don't care, I don't care.
Well, he says that's what I assume, and then he says that's what I heard. The source, I wasn't going.
I mean, yeah,
if we assume that the source of that's what I heard is Demekion Garlington, it would fall under this same.
Okay. All right, I just wanted to make sure.
I'll just point out at the bottom of 126, I think Investigator Dennis agrees with my view on these statements. That it's people putting their own version of their defense to try to say that they weren't involved. And that's the point I guess I'm trying to make.
So I suspect we'll see that on a slide during your closing argument. All right, yeah, no, my ruling is the same with regard to item 46. So that is in. All right, that takes us to 47. Which is on 129. I'm not sure I follow your objection. To 140, to your item number. Oh, wait a minute. Yeah, I'm sorry. 47. Your item number 47, 129, 1 through 14.
46, I thought we were on. But I will withdraw 46.
Okay. Okay, so now to 47. It says speculation about getting rid of guns, but the speculation about getting rid of guns seems to occur sort of after line 14. And your objection was to lines 1 through 14.
I agree, Your Honor, and I'm going to withdraw number 47
All right.
as
All
well.
right. Then moving to item 48 on page 140.
I'll withdraw that one.
All right. Seems to help you. All right, 141, line 11 through first part of 142. And is it your objection that the questions by the investigator are based on hearsay?
The questions are based on hearsay. You know, he's declaring, Investigator Dennis, they're inviting responses, I guess, but they're kind of more statements. He's saying that basically my client is involved in a list of shootings, and then he eventually lists them. One of them, I think we already discussed. Lucci's Mama House is the words he uses. We already discussed that I believe we already discussed that was based on what Mr. Zachary told him, which was based on hearsay. He wasn't there, so it's just based on rumors. He's just recapping what Zachary said, and what Zachary said has already been ruled coming out, is my recollection. So Lucci's Mama House, he said he did the bus. We've already established that Mr. Zachary wasn't present at the shooting of the bus, so Mr. Zachary wasn't allowed to talk about, or we're not going to play what Mr. Zachary said regarding who did the shooting. But so I don't know why we would allow Investigator Dennis to repeat it. And then the murder, I mean, that's a question for the jury here. And I understand that there's certain things that are helpful. Mr. Zachary says, I don't think he did the murder. I would like that to come in, but not in the context of Investigator Dennis listing a bunch of other shootings that are on this indictment that he's concluded my client has done.
So, Judge, the first thing is, it wasn't established that Mr. Zachary wasn't, it was established that he wasn't a part of the physical shooting, but it was also established that he was with other members of YSL at the compound and had knowledge of who pulled out, well, arguably had knowledge of who pulled out with whom.
Right.
So if we're talking about page, starting at line 11, from what I'm hearing, there is no objection to no, he does object to no Cassidy's. Your Honor, Mr. Zachary he's conveying something about Mr. Stillwell, at least his current iteration of events about Mr. Stillwell. He's saying he wasn't in a lot of shootings and stuff.
Right.
Dennis is saying essentially, what, really? And Zachary is reiterating the point. And then Dennis is asking for clarification. When Zachary says it's probably so many shootings, and then later on he says they go all the way back to 2014. He's clarifying information he's giving to Dennis, and he is giving information that we would argue he does have a basis for knowing. I don't have a problem taking out that he did the murder. But the three biggest ones from lines 6 through 7, we would argue that those are events or incidents which Mr. Garlington does have information about.
Okay, so I think that 141 lines 11 through 25. Are okay. Yeah.
Okay, so my specific on 11 to 25, page 141. What I'm specifically objecting to is when investigator Dennis says,
Can you pick up your mic? I'm sorry, I know that's
right,
kind of annoying, but
no, it's fine. He says right, and he just basically was from what I've gathered in basically interviewing people and him. Again, I don't know when investigator Dennis, to my information and belief, only spoke to Mr. Stillwell as a victim in a case where a young woman was killed back in 2015. So I don't know where in him comes from. He was quiet until it was time for some action, and then it was almost like sickle.
okay.
So he's like basically saying my client is, a leash pit bull.
Okay, all right. Okay, so then let's strike that question 11 through 14 because it's really not. It kind of interjects, and if you went straight from Zachary talking his answer from 7 to 10 and then pick up with what he continues to say 15 to 17, I mean that works just as well. So and you're nodding, Miss Love, you agree? Okay, so 11 through 14 are redacted by agreement on page 141, and then 15 through 25 of that page I'm gonna permit in. And then
So
yeah.
my issue with 142 is investigator Dennis says,
Yeah, now I'm getting to that.
Okay, I'm sorry.
And maybe you'll be satisfied.
all right,
I don't know, but whether you are or not, this is my thought at this point is 15 through 25 are in, and then redact on page 142 1 through 8 and pick up with line 9. And that avoids all of the Dennis saying something about a shooting that we. Okay, does that work for you, Miss Love? So Miss Love agrees to that. So Mr. Shart, I want to make sure that, so that you have any further commentary with regard after that ruling?
no, Your Honor.
Okay. All right, moving us to page 146. Okay.
Judge, good morning. Keith Adams on
Good morning.
Mr. Williams. So this is number 50 on Mr. Short's checklist.
Yep.
The entirety of this testimony, and the context of it is that this is a conversation where Mr. Sprinkle's involved, the detectives are involved, and they're talking to Mr. Zachary about what they believe to be a beef, for lack of a better word, between Mr. Williams and the Qantas Lamar, gentleman known as Rich Homie Quan. In short, my objection for this entire segment of the conversation, starting at 146, line 20, going all the way to 149.3, is that it's speculation. If you read through it, Mr. Zachary is opining about the reason that, well, first he's opining that there's a beef, in fact, a beef between Mr. Williams and Mr. Lamar, and he opines as to what the reasons are. The detectives are kind of interjecting their own take on what has happened and why they fell out. And if the most telling part is if you look at page 149, towards the end of that, and it really kind of starts at the end of 148, where Mr. Zachary is talking about how Mr. Lamar and Mr. Williams fell out. Birdman, a Rich Homie, fell out for some reason. I don't know, he says. Continues on to page 149, where the investigator asks him because he wouldn't sign. And then Mr. Zachary says, I don't know, I guess. That kind of encapsulates the fact that most of what he's talking about is what he's heard, what may be on the street. And there's no real basis where that speculation is coming from. So I'd ask that all of that be kept out because it's just speculative.
All right. Well, I think that you're right with regard to the very end of 148, top of 149, about Birdman and Rich Homie having fallen out, and the reason that might have happened being speculation on the part of Zachary. But that's kind of a separate topic from everything that they're talking about before.
Well, if you look at the entire, even starting back at 146 and going through, there are portions, for example, let's look at 148, the top of 148, line 1, where Mrs. Zachary says something to the effect of, and Rich Homie knew that they were shooting, that they had done shot up Thug. There's no way that he would know what's in Mr. Lamar's mind, what he knew. There's nothing to indicate the basis of that knowledge. And I will say that Mr. Lamar is a state's witness. He's on the witness list. We've been noticed that he's potentially going to be called. Birdman is on the state's witness list. Mr. Brian Williams. We've been noticed that he may potentially be called. And so these are witnesses that if the state intends to prove their theory, I'm going to say it's their theory, that there was this beef between Mr. Williams and Mr. Lamar, and that's relevant in some form or fashion. They have witnesses that they can call to do that.
All right, but they can corroborate their own witness testimony with something else if they got something else. So that's not an evidentiary objection. That may just be wishful thinking.
Well, I don't know if they're going to call those witnesses.
I don't either.
And if they want to corroborate, if they call them and they want to corroborate it, then they can say perhaps that Mrs. Zachary knew this in some form or fashion, heard it from those witnesses, but there's no indication that this is anything other than speculation on the part of Mr. Zachary.
All right. Ms. Love.
So, Your Honor, I think some context is necessary here. There have been repeated attempts by Mr. Williams to rebut evidence the state believes has shown that Mr. Lamar and he fell out after Donovan Thomas's murder. Okay. Donovan Thomas's father was one of our witnesses, and some of the questions on cross-examination involved Defendant Williams showing photographs of Mr. Lamar and Mr. Williams together at times that were after, I believe after the shooting, if I'm remembering the exhibits correctly. There were Instagram posts and things of that nature, a video of Mr. Lamar and Mr. Williams a music video of them that they both appeared in.
Yeah.
And that was after specific questions regarding Mr. Lamar's continued association with Mr. Williams after Mr. Thomas's death.
Okay.
When ADA Sprinkle asks in line 18 through 19 of page 146, so what happened? Why weren't they working together anymore? The answer Mr. Zachary gives, his basis for knowing that information, or at least broadly that information, is contained within the statements that he gives just prior to that, when he's talking about having been on tour, being on tour with Defendant Williams during this long period of time. So in line 9, when ADA Sprinkle asks, you know about Young Thug getting up on stage in March of 2015, calling Rich Homie Quan, bitch Homie Quan.
Mm-hmm.
And Mr. Zachary says, I was with him, yeah. And then ADA Sprinkle says, you weren't there? And Zachary says, I was with him when he said that.
Yeah.
So these statements provide a basis for Mr. Zachary's knowledge of whether or not Defendant Williams and Mr. Lamar continued to work together.
Okay, and I mean, I notice on page 147, line 19, no, line 20, I mean, Mr. Zachary's saying, like, basically, I stay at the same place as Thug does in that apartment building, too. So he's got a basis for knowing what he is saying on 146 and 147 and 148. Now, I agree that 149 starting at 23 is kind of a different topic and speculation, so I'm going to strike that, and the objection went through. 149 line 3, that I'm going to strike, but just that, the rest of it.
Judge, I just wanted to make one correction regarding line 20 of page 147. So it wasn't that reference was meant for Mr. Lamar, not, even though it says he, you have to listen to it. I think it was he, I think.
Oh, okay.
That's correct.
All right, thank you.
That's correct. What he's saying is that Rich Homie.
Okay, well, it says we, but I guess that's either a typo or a mistranscription. Okay. All right, so then, what is his basis then for knowing all of this?
I was about to say, but even with that, he's describing he's describing later on how much time he spends in the condo. And I believe at one point he even talks about the fact that he went down on one occasion and let somebody in.
Okay.
When asked how do people get in, they were trying to ask him about a call box, but he's saying, I went and let them in. No. So he spends and talks about the amount of time he spends, a lot of time with Mr. Williams in that condo. So my argument is that he, throughout the interview, he gives a basis for that knowledge.
Okay.
The only thing that I follow up with on that, Judge, is that's a different point, right? The fact that he knows Rich Homie Quan, the fact that he knows Jeffrey Williams, the fact that he knows where someone lives, the fact that he went and let someone in, does not give him the basis of knowledge of what is in someone's mind or why someone fell out. That's what the conversation is about.
All right. So, Miss Love, what's your response to that?
So, I would argue that his proximity with Mr. Williams and his association and relationship with Mr. Williams, as reflected in the fact that he's always at the condo, even on occasions when Mr. Williams is not there, is the basis for a knowledge of why they don't work together, and a basis for his knowledge of what happened.
Okay, and you have evidence that establishes their close relationship at this period in time.
Yes, his words, Mr. Zachary's words throughout the interview, are reflective of that.
Okay. Then I will stand on my prior ruling.
So just to be clear, Judge, what is the court saying will be kept out?
148, line 23 through 149, line 3. All right, we're at the bottom of 152 now. All right, Miss Love, why would this be in?
So we have already introduced the evidence of the Dexter Montgomery shooting. That's what this information is, starting at page 152, line 24. We have already introduced evidence that DK or Walter Murphy and Ard or Demise McMullen were the persons who committed the shooting that led to to the victim's head being blown, half of it. Mr. Zachary's assertions about who did that, I would argue, come from his relationship with members of YSL, with Walter Murphy and Demise McMullen, or other members of YSL. The portions where there is commentary by Detective Dennis, for instance, the part about page 153, lines 14 through 19, I don't have an objection to.
Right.
As well as lines 20 through 25, I don't have an objection to, because those are not things that Quindary Zachary is telling Detective Dennis. That's Dennis.
And how about 154, 1 through at least 14, but that's all just the investigators talking about basically their own investigation.
I don't have any
Frank? Yeah.
So there's a portion where Mr. Zachary is, you see it on the video, he's looking at what they're showing him. So where I don't have any problem with, for instance, 1 through 4, on page 154, I would ask that 5 through 17 be kept in, because that's the portion where he's
looking at pictures.
Right. Has just looked at pictures, and Dennis is now saying that right there is DK walking with an assault rifle.
All right. So that's 5 through 8.
Yes, 5 through 8.
Okay.
And as I think I just said it, but if I didn't, 9 through 14 is, I don't have any objection to that coming out.
Okay, but what about the rest of 154, basically? That's the investigators counting bodies. And all Zachary says is basically like, who are you talking about?
So, I don't have any problem. I don't have any objection, rather, I'm sorry, to that coming out. And so that's from...
That's basically 153 line 14 through 154 line 4, and then 154 line 9 through 24.
Yes, no objection.
All right, so let's circle back to 152 line 20. Through 153 line 13.
I don't have any objection to 153 lines 1 through 13. So I guess that's all of 153.
All right, so what about 152 17 to the bottom? Or 20, I'm sorry, 20 to the bottom. Although I think it's 17 to the bottom, because I think that's like the lead into...
It is. He's asking about the Dexter Montgomery shooting. I don't remember the exact words at 18, but it is.
Yeah.
I would argue that as to that,
I mean, I don't know, it may be significant to your case that he's even heard about it, so I don't know, you tell me.
well, that's the point that I was making earlier, was that it was his proximity and relationship with the other members of YSL that afford him the knowledge about Nard and DK doing it, and we have shown evidence that Nard and DK did it, so we would object to that part coming
All right,
out.
so 20 through 22 essentially then, or 17 through 22, you're saying that shows, although it doesn't show the basis, who he heard it from, but...
It doesn't, but if us with the
all coupled together would show he heard it from
other members of
okay. So, I mean, I think that then, could be relevant to the state's case, and you're offering it there. So he heard about it, and that they kept each other connected. So, that I will leave in. But what about, what'd you hear about it? 23 and 24 out.
No, 24, he says, you can't see it on here, but on the tape, I can give you the timestamp. He says, they say DK and Nard did it.
Okay. Okay.
I just don't understand how that's not hearsay.
It is hearsay. It's hearsay that is being permitted under the co-conspirator exception.
Who I would ask the state, who, if I'm permitted by the court, who told him this?
So, as I understand Miss Love's representations to the court, are that fellow members of the gang told him. Is that right, Miss Love?
The basis for his having that knowledge would be other his proximity and relationship and association with other YSL members. What I said when I first spoke on this is we would not ask for rank hearsay. We would establish a foundation, and if we don't establish a foundation, if we don't establish that it was a member of YSL, like if he's just like the streets talk, then we would not ask who did it or do you hear who did it, and then try to impeach him with what he said.
Okay, so essentially, as long as she lays that foundation, that's the basis of the witness's knowledge.
And just moving forward, and because I don't know the answer to this question, but I do know that Mr. DK is Mr. Murphy, Nard is Mr. McMullen. They were arrested and charged for this event. They may have already been arrested by the time they're having this conversation. I don't know the answer to that. But I just think that there's a lot of different ways that Mr. Zachary could come to that conclusion other than a co-conspirator statement. And I just want to be clear, we are putting... If they don't establish a foundation, should this tape be played, the ball is in their court to make sure all this is taken out.
All right, you clear about that? Okay, so make sure that that foundation is laid before, to the extent you end up needing to play this, that you have laid that foundation before you play it.
That is what I understand the purpose of this exercise.
All right, so we're clear then, assuming that foundation, 152.17 through 24 come in, all of 153 and 154 are out by agreement.
This case is stupid.
And we hadn't kind of picked apart 155 and the top of 156 yet.
All of 154 were...
Yeah, that seems to be what you ultimately agreed to. Oh, right. I'm sorry. With the exception of 5 through 8. Thank you. Sorry. You're right. All right, so how about 155?
I don't have any objections.
All right, 155 redacted by agreement. And then the top of 156, 1 through 6.
Yeah. I bet it is, boy.
I don't have an objection to 1 through 6 coming out.
Okay. All right, that's the end of that one then. All right. All right, so our next item is 157, 1 through 22.
judge need to hold loves Blazer in contempt. That's crazy.
Is asked on the previous page, page 156 at line 7, about his prior statement.
Right.
Shit.
Is he's acknowledging that he said it, he's maintaining what he told them in the 2015 interview regarding what two of the defendants on trial now said to him. But he is qualifying and asserting, acknowledging they said that they did, but offering as well his opinion, I don't believe it really did that. And so when Mr. Bailey at line 7 on page 156, what he's asking him, that is listed on the transcript as in the sermon is the first time that he talked to Dennis and Gaither, what did you tell them about Shin? And Mr. Zachary just sort of said, yeah, and Mr. Bailey asked to see the heat. I think a couple of times. And then at line 17, on page 1, he's talking about that he said, in line 15, 16, Mr. Bailey says, what did you say? He told you, and in response,
What is you doing?
Trying to get dressed.
Were you about to dip?
I gotta go to a girls' school.
Oh, I was gonna tell you. Well, I don't know. You can put my live up. I'm live right now. I'm reacting to this Young Thug shit.
Alright, I'm gonna get on you. First of all, you gotta respond to my friend request, sir.
What you talking about?
Yeah, I just came from your page and it still say response. Like it's still waiting for your response.
That's cap. I'll go check it though, baby.
I just came from your page. Like I'm like, why the fuck we're not friends? Like,
I don't understand. You looking pretty. You pretty this morning. You beautiful, babe.
Thank you, even though I haven't done my hair yet.
Yeah, I had to shave. I had to get that shit up off me.
I see that.
Yeah. Oh, I got off work like 2 in the morning last night. I was like, oh, fuck this shit. Cause I came home and then motherfucker asked me to go do some shit. As soon as I lay down, got off the phone with you, nigga, like, yo, I'm like, oh my god. So went out, did that, came back. I'm still tired.
It be like that.
Yeah, I mean, shit. I'm glad it's moving though. You know what I'm saying? For real. Yeah, I'm reacting on the joint. You gotta come on the joint, man, and talk to me on here and chat on the joint. I need some views. I need some views.
Come on.
For real.
To someone saying the hearsay.
And then I'll show you how to get this shit too. You got a laptop?
Yeah.
My objection is
It got a camera in it?
Yes.
Oh yeah, you lit. I'm about to get you the OBS shit so you can start going live if you doing hair, reacting to shit. You know what I'm saying? You would be a little bot. Watch when you click the link, you gonna see. I'm just in the little corner down there talking shit, smoking, watching this dumbass shit. They in the chat is going stupid right now. Not my shit. Not my shit. You about to be emotion in my shit for right now. What I'm trying to say is, yeah, they going crazy on the joint. So what you got to go up there? Huh?
He's repeating what Demekion Garlington.
That's the YouTube.
While he's trying to assert his innocence, and
Demekion
is putting himself out as being dropped off outside the car,
but yeah,
and putting Demekion,
I
excuse
ain't
me,
doing shit up
and
early.
eventually putting
What you gonna do with all that
Shannon,
pretty? What you? Nah, I ain't eating
Mr.
nothing yet.
Hendricks, Mr. McMullen, and Mr. Cobb.
I need some fruit. I want some.
It goes
Dude
back
had a honeydew
to
yesterday. I
the
said,
same
damn, I ain't had that in a
argument
minute.
I'm making, and I know
I
Your
need to
Honor
go to the
has
grocery
mentioned
store.
agreed with me in the past, but I still have to make the argument.
Let me
these are
find out
statements that Demekion Garlington
I didn't.
is
I told you I really just got up
to
not too long ago.
Mr. Zachary, not to further any conspiracy.
Nah,
but
I
to
got
get
this.
out of
I'm
jail.
drinking this.
And he's trying to put his narrative out there.
Huh?
That falls under we provided the cases to the court previously.
Nothing.
Stafford, Wilkins.
I probably should ain't nothing in there. Nothing at all. This is what it is. It's Gatorade. Trust me. I gotta rejuvenate. I got some. I'm on live, kid. Don't get me. What's your name? Like cussing, bro. We doing that. That's my nephew.
Carl?
Yeah, I'm reacting.
Alright, well,
Alright, baby, just check me out. I'm on the joint. Just hit me on there and chat if you got the time, or just call me when you're done doing what you're doing.
Alright.
My interpretation of it is that they are talking about up to a point at the very least, something that Shannon said. I don't disagree that it bleeds into comments about Demekion Garlington.
Huh?
And I'd ask for
Shit, since this morning, nigga. I was gonna go to work. She called me like I ain't gotta come. So
Friday when I was outside, all type of shit. Tino outside and everything.
Is he for real?
Mm-hmm. Well, not no more. He just went in their crib across the thing.
So in the 2015 interview,
I've been came down here.
Mr. Zachary tells police, and we'll get to that.
Since I know you're here though,
he tells
the
police that
Yo, where you about to go?
Get a shower.
Oh, okay,
he doesn't know
Tino will probably be back in like 20 minutes.
What in the world made them do that? And he was asked by Detective Gaither, made what do that? And Mr. Zachary says, people who killed him, Shannon, Yak, Nard. And then Mr. Detective Gaither says, Nard in jail for kidnapping. Mr. Zachary says, yeah, and Duop. He's then asked what Duop looks like. Then Detective Gaither says, how do you know this? Mr. Zachary says, because they told me. Detective Gaither says, who told you? In August 2015, Quindarius Zachary says, Shannon and Yak told me. Detective Gaither says, why did they tell you that? Mr. Zachary says, we were at the house talking about it. Detective Gaither says, which house? Mr. Zachary says, Thug's house. Question, new or old? Mr. Zachary says, the old one, his condo down there. Detective Gaither says, exactly what did they say? And then from there, a recitation of events that he says he got from Shannon and Yak. So the argument that this information came from Demekion Garlington, who was just trying to clear his own name, is belied, I think, by the information that the court will hear Mr. Zachary give in 2015.
In your honor, I don't dispute that Mr. Zachary has said that Mr. Stillwell, that he's claimed that Mr. Stillwell and Mr. Kendricks made statements to him. That's not the point. And when we deal with those statements, we can address, we'll address those statements in the arguments. But in this particular statement, and we can listen to the tape, my notes say on line 7, Demekion says that they were all in the car. They were all in the car. This information that we're dealing with right now, the source out of Mr. Zachary's own mouth, is the source is Demekion. And that's what's on the table before us right now.
All right, so if we go back to 156 line 7, which is where this objection, I think, begins. No, it doesn't. But, no, it doesn't. But if we go back there, at that point, they're talking about what Zachary told them way back in 2015, the source of which was the conversations amongst people at Mr. Williams' old Midtown condo. So close in time to the murder. And so on, y'all seem to know what a lot of the indiscernibles say. So on 156 at around line 16, I mean, they're talking about what did you tell them about Shannon? And then line 17, what's line 16 say? Do we know?
I'll tell you.
I can pull that up.
I'll tell you right now. In line 15 to 16, Charlie Bailey says in that interview, what did you say Shannon said?
Okay.
So that clarifies that portion.
Okay. So,
And Your Honor, it's only 1 minute from line 13 on page 1, or line 14 on page 156 to line 8 on page 157. So there's short intervals between them if there is a point at which we can play anything that helps clarify things.
And I understand that, but in that short interval, he switches to say Demekion says that it was all in the car. So I mean, it does. He switches the declarant, and that doesn't take much time to do, and that's what he did in this conversation.
Because I don't.
So I don't know who is, I see that it says Demekion told Shannon, but then it says Shannon didn't do it. He's saying they was in the car though. That he could be, who knows? That could be either of them. He said they was in the car when it happened, but they didn't see nothing. So I don't know what the basis for that.
Well, and that's Investigator Underwood talking at that point. So I don't know. Investigator Underwood's statement doesn't make a lot of sense in that context to me now, but I believe that the transcript is accurate.
So in 2015.
Alright, I'm gonna react to something else. Only because I know they about to have a break soon anyway. So when they go back live, probably double back. So what else? Shit. Excuse me. Thank you. Yeah, I wanted to see this.
Let's go ahead and get Mr. Copeland in.
Shit.
All right. Hello again, Mr. Copeland. Your attorney, Mr. Melnick, is with us by Zoom right now. You can see him on the video screen and he can see you. If there's any time you want to talk to him privately, let me know that. And I know y'all have had an opportunity since you and I spoke this morning from the bench in the stand to talk about the fact that the state is not interested in you pleading the fifth, and in order to avoid you pleading the fifth, they have secured an order that says you now can be essentially compelled to testify, because we are acknowledging that anything that you say, we cannot prosecute you for a crime other than perjury or false statements based on something that you might say that would otherwise incriminate you if it weren't for this immunity order. And if knowing that you still choose not to testify, the court can and will hold you in contempt. And what happens in that event is that you go to jail. And the length of time that you could be held in jail for, if you don't change your mind and say, okay, I guess I will take the stand, is through the end of this trial. I don't know how long it's going to last. I think previous projections had been February or March of next year. I don't know yet, but I guess that's not outside the realm of possibility. But it would only be through the end of this trial. It would not be through the end of whomever else might be severed from this case and tried later. And I know Mr. Melnick's talked to you in more detail about that. So I want to see if you have any questions of the court about that.
I didn't understand. Now you said at the beginning.
Didn't understand anything. All right, so
There you go.
I heard you, but I don't know what you're talking about.
Okay, so tell me what it is that you'd like more information about.
You said something about what they said about immunity?
Yeah.
What you mean?
Okay. Does anybody, I think I've got the order. Mr. Melnick, have you reviewed the immunity order with him?
Oh, you said it's the same from last time?
Hang on a second. Yeah, the same one as last time. Yeah. That's one. So that's the one I'm talking about. And that is still in effect.
So you're saying that changed?
It has not changed.
All right.
So what has changed is, it's my opinion that I cannot hold you in jail if you refuse to testify beyond the end of this trial. I think you had maybe been told something different earlier, and I don't think that is
So I ain't got to wait till every defendant that's not here.
Correct. But you would, if you choose not to testify despite this order, you would potentially be held in jail through the end of this trial, which might be February of next year, might be March of next year. I really don't know. It ends when it ends. And the state has 100 more witnesses, and I don't know, any defendant might also have witnesses. So it could take a while. But that would be the end of it, would be the end of this trial. Okay? So do you have any other questions? Okay. And do you want to talk to Mr. Melnick anymore about this particular issue?
No.
All right, so I'm going to ask you right now, because I'm planning to have the jury back on Monday. And I am going to tell them we would essentially start over, because I want you to have a voluntary, to an extent, choice and knowing choice whether to take the stand and be questioned and cross-examined or not, knowing that if you do, other than if you lie, as Mr. Melnick's discussed with you, and it's something the state knows and can prove, they could charge you with perjury or false statements, but they can't, if you incriminate yourself about another kind of crime, they cannot use that to charge you with a crime, and they can't say,
Well, can I speak?
You can. Yeah,
I have told the state I have lied and lied.
I know. And
so how are they gonna be able to question me?
I mean, that'll be their problem. That's their case to make or not make. I mean, that's not for you or me to worry about. So
they said they're gonna be able to charge me if I lie. Like when it's up to them to choose when I'm
not prior. You've said you've lied and lied and lied in every. I don't know what you've said, but let's even say you've said you lied in every statement you ever gave to the police. If you get on the stand and say that again, or if you say, all right, this one was the truth, that one they cannot charge you with perjury for, because those are things in the past. What they might be able to charge you with is, I don't know, I mean, give me an example of something that you know he didn't do, and, well, maybe not, never mind, don't do that.
Can I give you an example for what they told me?
Yeah, yes, and then I'll see whether that's what I think or not. Yes.
So she said that the only reason she won't lock me up, I just want to know if it's still a fact.
Okay.
She said if I do two things, if I plead the fifth, and I say that I killed Donovan Thomas.
Okay.
She said if I don't say them two, she will not lock me up.
All right, what was the first one?
Pleading the fifth.
Say it again.
Taking the fifth, Judge.
Taking the fifth, okay, right. And you can no longer, so taking the fifth means I might say something that gets me in criminal trouble. I might give you evidence against me that you can then use against me. That's what it means to take the fifth, is say, I am not going to give you evidence to use against me to charge me. When they give you that immunity order, immune just basically means we can't do this anymore. It's like if you get an immunization, oh, I'm not going to get the measles now, right? Because I'm immune from it. Because it's like getting you a shot that says, I can admit to a crime on the stand, they can't charge me with it. They have said you no longer have a privilege against self-incrimination because we have committed to not being able to prosecute you, not being able to bring criminal charges against you because of what you say. We cannot take that evidence and use it against you. We can't take that evidence. You know, if you say, well, I committed some crime, here's what I committed it with, I buried it in the yard, they can't go dig it up in the yard and then say, well, we've got this. They can't use any of that. So that's why taking the fifth at this point would get you in trouble. Being held in contempt is what we
So what if they don't
formally
have
call it.
they facts together? Like they saying something that they don't know what they're talking about, and then they ask me about it.
They can ask you about anything they want to. If in your answer you admit to a crime, they cannot charge you with that crime. Now, if you admit to a crime and they have evidence that is pretty certain that you did not commit that crime. For instance, somebody gets robbed yesterday and they have proof that you were in Europe yesterday. There's no way you could have committed that crime, but you say, yeah, I committed that crime yesterday. That was here in Atlanta when they know you were in Europe. And they got video of you in Europe and you sent a postcard that said, I'm having fun in Europe. That would be proof that you're lying. And so that they could charge you with perjury for, okay? Or false statements for.
Okay.
Okay? So, what I want to know from you is when we have the jury back on Monday and you're still under subpoena, so you're still obligated to come in, I'm asking you now, when they're like, all right, we're calling Kenneth Copeland, are you going to say, okay, ask me what you want to ask me, I'll tell you whatever I'm going to tell you? Or are you going to say, nope, I don't care if you throw me in jail, I'm not saying a word. I am not getting on the stand.
Depending on how we look.
Okay. All right, well then we will just revisit it on Monday morning. So plan to be here at 8:45 on Monday morning. You're free to go for now. Mr. Melnick, please be with us at 8:45 on Monday morning. Can you do that? Thank you.
There you have it. Now the ball is in, in Woody's court. The judge said, "Hey, man, the same situation that."
Yeah, Woody. I don't know. I'm like he went to court. Hey, man. Come on, Yeah, Woody, man. I don't know. He feeling like he ain't trying to do it. But, shit, I don't know if he wins Wednesday now, so I don't even know. I missed a couple proceedings. But yeah, I'm about to end this joint. I'm gonna start the whole another one right behind this. Let's tune back in if y'all.